Well, thank you all for joining us today. Today's topic is FMLA. How can I support my organization? With FMLA and EFMLA being one of the most popular and beneficial employment laws readily available to employers, knowing the ins and outs of how it can fully benefit employees is crucial. Today, we will go over the essentials supervisors and HR staff need to know about employment law in order to comply with company policies while also providing adequate opportunity for employees. We do have the Q&A feature available, so you can submit questions through that option. And if there's time at the end of the session, those questions will get addressed. You can also submit any questions to us via email. The email address is marketing@yoursummit.com, but I will display that email address again near the end of our session today. So let's get started. We have 3 guests joining us today. Our first panelist is Gracen Johnsen. Gracen is the Senior Vice President of HR Consulting for Summit, and she is responsible for the firm's human resource consulting disciplines, helping clients achieve their best practice and regulatory compliance goals. Enjoying a career as an HR professional spanning over 20 years, Gracen has served in the roles of HR manager, HR director, and HR consultant across a broad range of profit and nonprofit organizations and industries. Gracen is certified as a senior professional in human resources, SHRM Senior Certified Professional, a certified strategic planner, and an NASD trained mediator. And in 2017, Gracen won the Legend Award for HR Professional of the Year. Our next panelist is Richard Hardin. Richard is the Executive Vice President at ResourceOne Administrators. He oversees the day-to-day operations and sales of ResourceOne, where he develops, implements, and manages innovative strategies to protect clients with the best experience in self-funded benefits. Richard's passion lies in giving each member an exceptional experience with employee benefits by providing them with the tools and knowledge to make their benefits both accessible and affordable. And our moderator for today's session is Todd Rolland. Todd serves as president of Summit's employee benefits practice. Having been with the company since its founding, he has tackled the most unique and complex employee benefits situations. His experience is diverse and spans multiple industries. This perspective enables him to mitigate risk and guide clients to time-tested and creative solutions. Todd's professional designations include Certified Employee Benefits Specialist, Registered Employee Benefits Consultant, Retirement Plans Associate, and Group Benefits Associate. And now I will pass it on to Todd to begin our session.
Thank you very much, Megan. Thanks to all of you who are joining us today. We appreciate you participating with us. We're excited about this today, and Grace and I and Richard were talking about this prior to. This regulatory compliance benefit related issue of family medical leave is perhaps the most misunderstood element within that landscape that we're dealing with, or that we've had to deal with certainly this year. Several reasons and several influencers as it relates to that, one of which we all are living with every day, and that's the pandemic and dealing with the new norm. But it certainly has brought up several different issues with our clientele and with friends of Summit, and just relationships we have that are leaders within organizations, and how they should best manage this area. So it's become, I think, even more complicated as a result of the pandemic, which has caused some really odd situations and occurrences as it relates to leave. So I couldn't be more thrilled. Gracen and Richard, thank you all for attending today. And I might also just mention that this session, Gracen is going to carry the bucket of water, if you will, is the way I would describe that. So I won't be asking a lot of questions and answers, or a lot of questions rather, and waiting on Gracen to respond, simply because the magnitude of the information is pretty broad. So we want to get to it all. So with that said, Gracen, you're looking good. Thank you. Talk to us about FMLA. Talk to us about the expanded FMLA and some of the differences and what this means to our clients and friends.
Thank you, Todd. And it's good to be here this morning. And And I'm glad to see Richard joining me on this. He and I have worked together on FMLA issues, which he will be generous enough to share some anecdotal information with us on the kinds of issues that employers can face. The expanded FMLA has really confused the issue, especially for employers, that have fewer than 50 employees and are not accustomed to dealing with the FMLA at all. Where the expanded FMLA applies to all employers with 500 or fewer employees. So have been working a lot with clients and, as you said, friends of the company, helping them negotiate the differences in that. A big difference is that where the Family Medical Leave Act requires employees to have been with the company for at least 12 months, and I'll go into more detail about that eligibility. Under the expanded FMLA, the employee only needs to be with the employer for 30 days before they're eligible for it. Also, the expanded FMLA is specifically for childcare. It is for employees who are unable to work, and that includes telework, because they must be at home to provide childcare for minor children under the age of 18 whose school or place of care is closed. It's very specific for that. It includes 12 months, as does the FMLA, 12 weeks over a 12-month period. However, they run concurrently. So that means that if an employer is eligible and their employee is eligible for the traditional FMLA, the 12 weeks under the expanded FMLA is the same 12-week period. It doesn't mean that all of a sudden you have 24 weeks of unpaid leave available to you. If you have already used, for example, as an employee, part of your traditional FMLA allowance, then that's all the weeks you have left, even for the expanded FMLA. So that can just get really confusing.
Yeah. Gracen, if you don't mind, I might ask you a quick question. I hadn't planned on this one, but just to clarify. So the traditional FMLA, we hear a lot about the 50 or more, and then we hear this 75-mile radius provision that has created, I know historically, a lot of confusion. Can you speak to that just real briefly?
Absolutely. In order for an employer to be eligible for the traditional FMLA, that was actually written into law in 1993, so it's been around a while. Yeah. They must have 50 employees over a 20-week period, either in the current year or the previous year. And those employees must work at a location, at a work site that within a 75-mile driving radius, not as the crow flies, but a public transportation radius or a car radius within that 75-mile radius. So let's take, for example, our own company, Todd. Our Tulsa office may be close to 50 employees, but let's assume that it is at 50 employees and is eligible for the FMLA. The Oklahoma City office would not qualify, would not be eligible for FMLA because the Oklahoma City office is more than 75 miles from the Tulsa office.
Okay, excellent, excellent. I think that's a very good clarification, because I know that, 200 employees, there's an automatic assumption and conclusion, and that may not actually be correct based upon that radius provision, the mile radius provision. And so that's good. That clarifies that. So thank you.
You're welcome.
Sorry to get you off track a little bit.
Oh, I'm used to that.
Okay, let's talk about just some employee eligibility issues, and as an employee, what really dictates an employee that's eligible, and some of those related issues.
Okay. The employee eligibility can get complicated and confusing. As I mentioned just a moment ago, under the FMLA, an employee must have worked for their employer for 12 months. Now, what's interesting is that those 12 months do not have to be consecutive. Now, that's important for a company like one of my clients is a long-haul trucking company, and their drivers come and go. And their drivers may not be there for an entire block of 12 months. But what you can do within the 7-year period is that you can actually add all those months together to see if they have actually worked for 12 months. But that's just the first step. The second step is that the employee must have worked for the company 1,250 hours over the preceding 12 months preceding where they want leave to start. So that's an important piece of it. So that's not an or, it's an and.
Yeah.
So it's important to look at that. Also, it's important to know, I mentioned the 50 employees for the public sector and for educators, for the education system, either public or private. It doesn't matter how many employees they have. They are eligible for FMLA, and I wanted to clarify that just in case we have anybody working for a public sector on this call.
That's a very good point. That's a very good point. So, and as well as education, you mentioned, right? So both private, public, elementary, post, up at the university level, doesn't matter. Education.
Right.
Okay, that's excellent. That's excellent. How about some of the basic provisions? This one carries quite a bit of weight. There's a lot of detail around it. Can we talk about some of the basic provisions of FMLA?
Okay, you're right. There are a lot of basic provisions under the FMLA. The FMLA was enacted so that employees can take unpaid leave of absence to care for their own serious health condition or that of a family member. And then more recently for military caregiver, which I'll go into in a moment, without fear of losing their jobs from their absence. It protects their jobs, and it also protects their benefits. It also requires employers to return an employee to the same or similar job that they were in before they took their leave. So it was hopefully created so that the employees did not have that concern in addition to their own health or their family members' health issues. But there are 6 FMLA instances specifically that's covered. The first one is the birth of a child and to care for a newborn child. Now, what I'm finding that a lot of employers miss is that birth of a child includes prenatal care. So every time your employee leaves to go to their physician for the prenatal care, that is counted as FMLA leave. And that also, interestingly and importantly, applies to the other parent, whether that is a father or if it's same-sex marriage, it's common law marriage, it applies to them too. They also have 12 weeks to deal with the birth of a child and care for a newborn child and to bond with the newborn child and to go to those prenatal appointments with the mother. of the child. However, if the couple works for the same company, they have to split that time. So they have to figure if they're each going to take 6 weeks or one's going to take 4 weeks. It's important for them to understand if they work for the same company, they've got to split that 12-week period. The second is the placement of the employee of a child for adoption or foster care. And that also includes the bonding time. It includes all of the appointments that lead up to that foster child or the adopted child. And so and it applies to both parents. So that's, it's 12 weeks. And so if you have an employee that's getting ready to adopt and they have to go to counseling, they have to have legal work with it, all those things that are involved with the complications of adopting a child or placing a child in foster care. It even would cover, they may have to go out of the country for the child. So that is covered. The care of a spouse, child, or parent who has a serious health condition. So that is also 12 weeks of unpaid leave. And it covers the serious health condition of your spouse, the serious health condition of a parent, and that could be an adoptive parent, a step parent. So it doesn't have to be a biological parent, or it could be somebody who served in loco parentis, meaning they took a parental role and responsibility, but were not necessarily the biological parent of the individual. But it does not include parents-in-law.
I see.
So if you have 2 employees who are working for the same company or 2 different companies, they could only take leave to care for their own parent, not to care for an in-law. Also, the serious health condition of the employee. And it's important to understand what includes a serious health condition. But the serious health condition makes them unable to work. It could be a physical impairment, it could be a mental impairment, but it makes them unable to work for a period of time. And finally, the last 2 conditions or criteria is a qualifying exigency for families of members of the regular armed forces who are called to duty overseas, out of the country. So not for an employee who's in the reserves and they're going on their 2-week training that's required every year, but for military family members, parent, father, mother, or child who is being called to active duty. There are 12 weeks allowed to deal with that. And I don't know how many of our viewers and callers have been exposed to what happens when somebody is called to duty who serves in the military. But I was married to a Navy officer, and when he was called to active duty, there was a lot of things that we needed to do to prepare for that. And he was gone for more than a year. So, so it's important to deal with that. And finally, the care of a spouse, son, or daughter who has been injured or become ill based on that same call to duty. These people are put in harm's way. They don't always come back whole. And but in this case, the caregiver is allowed 26 weeks rather than 12 to care for that individual. And those last 2, the military related ones, are the newest additions to the Family Medical Leave Act.
I see. I see. I might, another question that I have, that I have, Gracen, And as a result of the pandemic, the behavioral health issues, psychological issues,
Mm-hmm.
that behavioral health has, it's become a frontline issue, right? With many
Mm-hmm.
of us dealing with a pandemic, many folks dealing with a pandemic. So can you speak to that a little bit? Have you seen in your experience employers that have been having to deal with just psychological issues? I need time off because I can't concentrate. I'm afraid.
Mm-hmm.
Just as a result of all of the real threat and the buzz related to the pandemic, they just can't do the job. And is this something that's debatable, or is it just black and white?
Well, one of the things I've learned in the 20 or more years that I've been doing this is that nothing's black and white.
Yeah.
But
Sure.
but basically, fear to come to work is not covered under the FMLA or
Okay.
under the emergency paid sick leave. It is not covered by the ADA. So if an employee is fearful to come to work, or they're just feeling stressed and need the time out, but they are not under the continuing care of a healthcare provider who is treating the person for that stress, that would probably be covered by any PTO that the employee may have, or if the employer has a policy of leave of absence that is not FMLA leave of absence, that they would be able to use that. So, that's an important distinction. Now, one of the things that's important too, and this is one of the reasons why I was anxious to talk to our viewers, is that sometimes the employer is the last to know that an employee is out on FMLA leave. It is very critical, and it is among the provisions of the FMLA that supervisors, managers be trained, maybe even once a year, on what to look for. An employee is unlikely to come up to their supervisor and say, I need FMLA. Instead, an employee is going to come up to the supervisor and is going to say, you know what, I've been scheduled for surgery, and so I'm going to be gone for 2 weeks, and but not to worry, I have PTO left to cover it, so I don't need any other help with that. Well, that's a clue for the supervisor to say, you know what, this is a qualifying event for the FMLA. You're going to get inpatient care, then you're going to have after the procedure care. You need to go by HR and talk to them so that they can start the process to designate this as FMLA leave. Under most circumstances, and the Department of Labor really emphasizes this, it is the employer's responsibility to designate leave, even though it is the employee's responsibility to notify the employer. It doesn't always happen. So supervisors and managers who have that one-on-one relationship with the employees, they're generally the first to know. They need to understand what a serious health condition is, all the criteria that I just mentioned, the 6 issues, so that they can recognize it and say, you know what, I think this may be an FMLA issue. We better talk to HR, because HR doesn't always see all the employees all the time.
Right.
So it's really critical, and it is that issue that employers can really struggle with. I have talked to employers who have said, gee, Gracen, I just found out that the employee that I thought was on a cruise for 2 weeks was instead in the hospital, but they're already back to work.
Yeah. Yeah.
Yeah, so, or they told their best friend, but they didn't tell anybody else. So
Right.
it's important, and that the employers have the FMLA Department of Labor poster included on their labor posters that are posted in their workplace, and also that they have an FMLA policy in their employee handbook, and that they train the employees as well. The employees need to know what their rights and responsibilities are. And one of the reasons for that, or the big reason for that, is that the employer, once they are notified of a potential FMLA absence of an employee, the employer has 5 business days to get the eligibility and employee rights and responsibilities back to that employee. And the Department of Labor has excellent forms that are free and can be filled in online. If you're using those forms, please make sure you're using the ones that came out in June of this year, June 2020. So make sure you're using the most current forms. And it provides all of the information that you need to give that employee, including telling them that, yes, you are eligible. You have been here for 12 months. You have worked 1,250 hours over the preceding 12 months, but we don't quite know yet if your absence is FMLA eligible. So with that notice, a medical certification form is generally provided. Now, the only time that you do not need to or should not provide that form is in the event of pregnancy. So unless the pregnancy has serious complications or the birth has serious complications. But so you give them the medical certification form, and they have then 15 calendar days to return that medical certification back to their employer that's been completed by their physician. And at that point, then HR or whoever, the benefits administrator, whoever's responsibility in the company to do this, they should have the information they need to determine whether or not this leave of absence really does qualify as FMLA leave. But it's also important to look carefully at that form to make sure that it's all complete, that the doctor has not left anything blank, because that form has to be complete. If the form has not been completed, you would inform the employee that you cannot designate it as yet because the form is incomplete. Then you can generally give them another 7 days to get that back to you. After you receive that back, you have 5 business days to notify the employee of whether or not that leave has been designated as FMLA leave. So the clock is ticking. The clock actually starts ticking with the employee. The provisions are that the employee is supposed to notify the employer 30 days before a scheduled absence. For example, if an employee says, you know what, my doctor says in the next couple of months I'm going to have surgery, they need to notify the employer 30 days before that happens. However, there are times that that isn't possible. It could be a sudden illness. The doctor says we've got to do this right now, or you become ill suddenly. At that point, then you need to notify the employer, the employee needs to notify the employer no later than the next business day or as soon as practical. So those are some of the responsibilities of the employee. And that's why the employees need to be trained on this too. But I can't emphasize more that the employer is not the only one with responsibilities. The supervisors, the managers, it's critical that they be on top of it and that they notify the employer.
Yeah, excellent. Well, those are great points, Gracen, and I know we're going to transition through to key employer requirements and follow that with some employer actions that are prohibited. But at this point, why don't we let you take a breath for a moment and catch your breath, have a sip of coffee or something of the like, and Richard, I want to turn to you for just a moment. Richard, as an executive who leads an employee benefit administrative organization, third-party administrator, you see a lot of things, and you experience occurrences and incidences that really relate to the eligibility of a participant, the ongoing eligibility, et cetera. So I know particularly with COVID and the pandemic and people being off-situs, is it FMLA? Is it not? How about employee benefit eligibility? So if I have health coverage, I need to be, very judicious if I'm an employer in complying with the requirements. I also need to be very proactive as a participant within a health plan in terms of communicating effectively with the employer, because at the point of a claim resulting from a serious illness, this could become quite an issue, right, Richard? So, just pragmatically speaking, can you speak to that, and no specifics and certainly de-identified, but just some of the things you've seen that your landscape has been dealing with as an administrator who administers medical, prescription, and short-term disability plans, as well as dental for large self-funded employers. So there's some gotchas out there for sure. So can you speak to that just a little bit?
Yeah, absolutely. And it's one of those situations where we have found our clients, and typically what we see is because of the landscape of the business and what's been going on, really, this is a situation that doesn't occur, on a monthly basis. These are in some cases, they can happen once or twice every couple of years. And so we found a lot of our clients have been reaching out, asking a lot of questions. And I don't know if it's in relation to COVID. I want to say it does tie to that, but I definitely think it has a role. One thing that we really try to emphasize is that the plan document, the employee handbook, and the stop loss policy are all in alignment. We want to make sure that the policies and procedures that are being followed by HR and the employee are all in alignment with what's being with the stop loss carrier, make sure that they're on the same page. We have found situations to where the plan document does not match, which the plan document acts as the Bible, we like to say, for the medical plan, doesn't match the employee handbook. And so we've got situations to where we've got groups out there that could have some risk or exposure to where stop loss wants to dispute a claim saying that you did not follow the policies and procedures of the plan document, but they follow the policies and procedures of the handbook. So a lot of times we really want to emphasize that everything is in sync and everything's in alignment, and make sure that you're following the same timelines and protocols when it comes to hourly requirements, when employees return from FMLA, to making sure that FMLA should be offered, that the employee did meet the requirements, to make sure you do have over the 50 employees. A lot of those type of criteria we're seeing are very crucial and very important.
Yeah, those are great comments, Richard. And I personally, in working with our group of valued employees, with our clients, I've been involved in situations this past year where there have been claims questioned that were filed under a self-funded plan, primarily specific reinsurance claims. So, that more meaningful, significant claim that most times is up into the 6-digit figures and sometimes many multiples beyond 100,000. It could be $500,000, greater, even over $1 million. And the last thing we want for any of our clients or any employer out there is for that reimbursement to be questioned because of a compliance issue related to FMLA and how you're actually administering FMLA. So yeah, I think that's a very important note. Our clients and employers out there, you all know, if you're self-funded, you play, the biggest financial risk that you may have is that catastrophic claim. And for that claim to be questioned or denied would be extremely unfortunate. And we've also seen, I might just add, that it's really the employer has the obligation to handle FMLA correctly. The employees have some skin in the game as well in terms of communicating effectively with their employer. But then thirdly, I would also say that from my perspective, I think it's critically important that the reinsurance industry that's providing coverage for some of these benefit plans, that you vet very comprehensively the credibility and the reputation of that reinsurer, because we're in a time where, frankly, a lot of the insurance companies out there are looking for ways, in my opinion, or at least they're very hypersensitive to their ability, because of the circumstances we're dealing with, to be able to deny a claim. And so it's just the stakes are pretty high in that regard, certainly. And I think those are great comments, and something that our clients and our prospective clients need to consider.
And Todd, I will say one of the things that makes our clients the most successful is when they've over communicated with us. You know, when they've reached out, they've had one of these situations come up, they've called on us before to make sure that we're all in alignment, that they're handling it appropriately. So a lot of times our clients have over communicated with us as well, to make sure we're all on the same page. And so when we do have the big claims that are going through, if you have a patient that's really sick and they're off work for a time period and they're communicating with us to make sure, you know, when we're following the stop loss claims, that there's that type of communication is definitely crucial. So we found that those are the clients that have been the most successful during this time.
Yeah, yeah, great comments. So what I hear you saying globally, Richard, is be as an employer, be keenly aware of the major requirements, and from a benefit planning perspective, review your employee handbook, review your reinsurance contract, make sure the verbiage is in alignment as it relates to FMLA for sure, and of course the plan document, that all the language is in alignment. I think that's a very good point. So I appreciate that, Richard. Anything else on your mind relating to that now?
Nope, I think we covered it.
Okay, thanks for sharing. Gracen, I'm going to do something that's a little different and not really planned, if you don't mind. We have a couple of questions. So before we jump back into key employer requirements and follow that up with employer actions that are prohibited by FMLA, we have a couple of questions. And one of those questions, Gracen, is why would an employer not require the certification form for pregnancy? And I might add that I'm going to de-identify and I'm going to respect privacy, but you know this individual asking the question. I just won't tell you who it is. So,
uh-oh.
Very intelligent individual. So, why would an employer not require the certification form for pregnancy? Or would they?
Well, frankly, the law actually says that the employer cannot request medical certification for pregnancy or for the foster care. Why they said that, I don't know. But that's a good question. That's probably above my pay grade to answer.
Yeah. Okay. Well, thanks for your comments there. Another one is for the father of a child going to prenatal visits, are those visits restricted to leave for the woman who has severe morning sickness or other complications to be eligible for FMLA?
No, if they're healthy prenatal visits, you're going to learn the gender of your child, for example. That is something that a father can do to go with the mother of the child. So all those prenatal visits are covered under the FMLA for both parents.
Excellent. One more, Gracen, then we'll turn back to the agenda there. The question states, can you please address if the employee is out on a work-related injury that is going to take them out for a while, what the rules for the employers/employee would be regarding this type of situation?
That is an excellent question and a perfect segue, because that was what I was going to talk about next.
Yeah, great.
So thank you for that question, whoever put in that question. It is important to understand that there is a lot of overlaps with the FMLA and other laws. FMLA runs concurrently with workers' comp and short-term disability and ADA. But it's also important to understand that the FMLA is unpaid. So what you're doing under the FMLA is you are protecting that job and protecting those benefits. And that's why also it's important for employers to run any unused PTO concurrently with FMLA as long as it lasts into that employee's leave, because that way they can continue to take the distribution out of the paycheck to cover the cost of the benefits until that runs out. And also the employee will have some income coming in. It's important to check to see if the employee is eligible for short-term disability when they go out on leave. And that certainly applies to pregnancy. Employers who have employees that are considering starting a family or adding to their family, short-term disability is something that I really encourage employers to do. Now, I don't have an insurance license, so I can't sell it. So this isn't a sales pitch. This is just from experience that it really, that is covered under short-term disability. Yeah. So that is something to think about for your employees.
Yeah.
And but it's really important that the employer make sure that they are addressing that. Now, I keep talking about the benefits being protected, Todd, and what that means that they are protected under the same conditions were the employee not out on leave. So the employee is ultimately responsible to pay their portion of the benefits, which is another reason why it would be good for short-term disability to help them do that. So employers may make an arrangement with the employee to help them out with that, but they need to make sure that that's in writing and that the employee understands the liability should they not return after leave.
Yeah.
And their responsibilities. So there are ways that you can do that. If the employee cannot make those disability payments, benefit payments, then if you don't have an arrangement with that employee, then at that point, you can terminate that employee's coverage and send them COBRA notification.
Yeah, I might interrupt you just for a moment, Gracen. I know I see here, I'm checking our clock. We've got about 17 minutes and I think you've got a lot more to cover, but this is a huge issue. This is a really big issue that you bring up as it relates to, FMLA and the benefit that a participant within a benefit plan, let's just say it's medical and prescription coverage right now, they've utilized all of their PTO. They're off on FMLA, unpaid leave, and the employer, many of the employers, my experience and my observation is they have a desire to continue, they have every reason and intent to continue that benefit for that employer, that participant, but there's a lot of confusion when it comes to the payment area. Right. I mean, I've several times, I've been involved in discussions where it's like, okay, so how do we secure the payment? And what if we don't get the payment? And what if there was an extraordinary occurrence that precluded payment being made? So back to Richard's point, all of this becomes very important in terms of the eligibility, the ongoing eligibility, when you offer them COBRA, if they're on FMLA. And I think your point that you mentioned in terms of communication and some kind of an arrangement or some kind of an agreement with your employee, if you're an employer out there, is critically important. Because many times I have seen where, it's just everybody's, we're busy doing what we're doing. All of us are in life. And so FMLA, some kind of transaction comes up. People are involved and they're too busy. A discussion never occurs, and then payment can't be made. So I think that's a very good point. And something that we all ought to be thinking about for sure. So I appreciate
Exactly. And also remembering that whatever you do with one employee, you've set precedent.
Yeah,
So think about that too, because you don't want to discriminate between employees inadvertently. Another law that can run concurrently with FMLA, Todd, is the Americans with Disability Act. And I have had many conversations with clients asking about our employee cannot come back to work yet. They are still ill. They are exhausting their FMLA. Do we have to terminate them? Well, the answer to that is, well, like a lot of lawyers say, well, it depends. If the employee's illness or injury or surgery is covered under the Americans with Disability Act, you can extend that unpaid leave beyond the FMLA with unpaid leave under the ADA as reasonable accommodation. Now, that will continue to protect their job, but it does not protect their benefits. So the employer is still going to have to work with the employee. But it's important too to understand that applies only to the employee. It would not apply to caring for a parent or son or daughter.
That's
so
great.
It would only apply to the employee.
Great point. Okay. How about employer requirements or actions prohibited?
Actions prohibited. There are prohibited actions. And
there are.
there always are.
Oh, yeah.
I've been talking about all the things you can do, or what are some of the things that you must avoid doing. And one of the things to avoid doing is don't make pre-hire inquiries about FMLA, regarding FMLA leaves during the interview process. You can ask them, have you recently been on FMLA? Have you ever used FMLA? Do you anticipate being on FMLA? Don't even go there. It's just like in any interview situation, you don't ask health questions. Also, you need to include periods of FMLA leave when making decisions regarding attendance awards or non-performance bonuses. Don't count that FMLA leave towards attendance. It is protecting the employee. That's one of the reasons why it's important that employees understand that they need to let their supervisor or HR know their need for leave. Also, don't ask for a doctor's note every time an employee leaves for intermittent leave. Which reminds me, of course, that FMLA does not have to be taken in blocks of time. It can be taken intermittently. That's important for employees with chronic health conditions such as diabetes, migraines, conditions that will flare up. But those employees for those chronic health conditions still need to be under the care of a physician and see them at least twice a year for that condition. But intermittent leave, that still has to be tracked. And but you don't ask for a doctor's note every time they come back from intermittent leave. Employers are prohibited from doing that. Also, you cannot interfere with an employee's rights or retaliate against employees who file FMLA complaints. So that is why it is so important that the employer be notified about FMLA, because if they miss that, they don't realize the employee should have been on FMLA, and that employee is later terminated because they been missing too much work and they should have been under FMLA. You can understand that that would be a huge liability. You would be interfering with that employee's rights. Yeah, it is the employer's ultimate responsibility to designate leave as FMLA leave.
Yeah, good point. Good point. So we've got a little bit of time left here. Gracen, any other things on your mind? We've got a few questions here. I think we've got probably, before Megan finishes up, we've got about 5 minutes here. So if you don't have any other thoughts, I'm going to transition over to a couple of other questions, if that's okay.
Absolutely.
Okay, all right. The question is, if on workers' compensation and being paid by work comp directly, just to confirm, you cannot claim short-term disability, and it is not mandatory to use up the employee's PTO.
Under workers' comp, that's correct.
Okay.
But they can still be running FMLA concurrently that protects the benefits and the job. So if they're out on workers' comp that falls under the FMLA serious health conditions, whether it's physical or mental impairment, and they are unable to work because of that, that is an FMLA eligible issue.
Okay. Okay. Very, very good. Okay. Another question. Would a return to work release be okay for the employer to request from maternity leave employees or participants? Beneficiaries.
You can, especially if it was not a natural pregnancy, if there were issues in delivery or an illness related to that pregnancy, you can request a return to work. You can also do that for all the absences. Even if you're taking care of the serious health condition of a parent or a child, to make sure that that employee really can return to work, that there's somebody else who can care for that individual, but absolutely for their own serious health condition and for pregnancy.
Yeah, very good, very good. Gracen, let me ask you here in the final few moments, and won't hold you to this at all, but say the top 3 or 4 things in your mind that are really important that revolve around FMLA for employers. What would those be that would just jump out? And again, that might change depending on a discussion you're having with a client on any given day, right?
That's right.
But in terms of, our discussion today, just, the things, hey, Todd, here are just a few of the things I think are really, really important that you just want to re-emphasize again for our attendees.
Oh, absolutely, Todd. Communicate. You have got to have the FMLA poster with your other labor law posters. You have to have an FMLA policy in your employee handbook, or if you don't have an employee handbook, that you still provide them the policy for FMLA. That is a requirement under the Act. And to train the supervisors and the employees on the FMLA so that they're made aware of it. And so that education piece is absolutely critical. Also, it's absolutely critical that the employer get the eligibility, rights, and responsibilities notice to the employee within 5 business days of learning of the need for leave, that they get that medical certification back within 15 calendar days, unless there are other circumstances that though the employee made a good faith effort, they may need more time to return that. Make sure that certification is complete. And by the way, if the employee never gets you that certification, then FMLA is denied, because that certification is what confirms the need for FMLA.
That's a great point. Yeah.
And I think under pregnancy, it tends to be obvious that the need for leave for that. But it's so just really communicate, get all that paperwork back to them, make sure you get the designation, whether it's denied or confirmed, back to the employee within 5 business days to notify them of that. That is carved in stone. And the Act will actually say that you are infringing on the employee's rights if you do not get that information to them timely.
I see. I see. Excellent. Well, Gracen, thank you for those comments. Thank you for sharing all of this information with us. I personally have learned, I've had a couple of aha moments, and I'm sure those out there listening found it very valuable as well. And Richard, thanks for your comments as it revolves around and regarding employee benefits. So I've appreciated the time with you all this morning. Thanks to our attendees for hanging in there with us. And we hope we found it valuable. Megan, I'm going to go ahead and turn it over to you at this point.
Thank you very much. Well, I would like to thank Gracen, Richard, and Todd for their time in sharing this valuable information with us today. And we would like to thank all of you for joining today's session. Please be sure to follow us on social media. We have another webinar scheduled for Thursday, November 12th. This session is titled Anticipating the Unexpected, featuring Karen Drancic, Senior Vice President for Neuberger Berman Advisor Institute, and Casey Skidgel, President at Summit, as we navigate how business owners, families, and their loved ones can be better prepared for life's unforeseen events. So please keep an eye out for more information on that, and we hope that you will be able to join us. We also have COVID-19 resources available on our website, so also please take a look at that for more information. But for now, thank you very much for joining us. Have a great rest of your day and stay safe.
Thank you.